Good afternoon, ladies and gentlemen. Welcome to the Immigrant Edification TV. This is your host, Elgin Martinez. The video this afternoon is going to be about a new law that was passed on Monday in reference to the new public charge law that was being implemented by the Trump administration. What I'm going to do is basically read an article from CBSnews.com, Washington. The Supreme Court on Monday allowed the Trump administration to enforce its most ambitious effort yet to restrict legal immigration, giving U.S. officials the green light to implement a sweeping rule that critics warn will shut America's door to low-income immigrants and people of color. In a 5-4 ruling, the conservative-leaning High Court approved the Trump administration's request to set aside a ruling by a federal judge blocking the so-called public charge regulation, while the merits of the case continue to be argued in lower courts. The court's conservative, including President Trump appointee Brett Kavanaugh and Neil Gorsuch, agreed to allow officials to enforce the policy, while the liberal justice would have denied the administration's request. By dramatically expanding the definition of a public charge or an economic burden on society, the U.S. Citizenship and Immigration Service regulation unveiled in August gives officials more power to deny visas and green cards application from immigrants and the prospective immigrants whom the government determined could rely on certain public benefits like food stamps and government housing programs. For decades, the U.S. has asked most green card and visa petitioners to prove they won't be a public charge on the country. But the new rule scraps Clinton-era guidance that said only the use of cash benefits could be analyzed by immigration caseworkers. The Trump administration had defended the new restriction as a way to ensure immigrants are self-sufficient. But opponents believe the policy is an attempt by the White House to circumvent laws passed by Congress by instituting what's essentially a wealth test designed to limit the immigration of poor people from the developing countries. If you listen to Trump talking about how he wants a point-based immigration system and want people who are wealthier, better educated, higher skilled, and not from countries he's spoken of in derogatory, profane language, this is it. This is the policy that aims to do that without Congress approving it whatsoever, said Doug Rand, a former White House official under President Obama who co-founded Boundless, a company to help immigrants navigate the U.S. immigration system. It's a way to screen out people, not just from developing countries, but from any country that the government has decided aren't wealthy enough, aren't healthy enough, and don't speak English well enough, Rand added. Soon after its final version was published last summer, the public charge rule was blocked in court, with one federal judge calling it repugnant to the American dream. However, in recent weeks, Circuit Court lifted 3 of the 4 nationwide injunctions against it, leaving only an order by a federal judge in New York standing. Earlier in January, the Justice Department asked the Supreme Court to set aside the remaining nationwide injunction, a request that has not been granted. U.S. immigration officials will not be able to implement the new restriction in every part of the country other than Illinois, where the rule is still blocked under a statewide injunction. In a concurring opinion joined by Justice Clarence Thomas, Gorsuch expressed profound concerns about lower court judges issuing nationwide injunctions that transcend the cases before them. He said both the government and those suing it are rushing through cases with national implication in the hopes of obtaining emergency ruling instead of methodically developing arguments. The routine issuance of universal injunction is patently unworkable, showing chaos for litigants, the government, courts, and all those affected by these conflicting decisions, Gorsuch wrote in his concurring opinion. Ken Cuccinelli, an immigration hawk and the second highest ranking official at the Department of Homeland Security, said his department is making preparation to enforce the public charge policy following the Supreme Court decision. Self-sufficiency and self-reliance are key American values, not to be litigiously dismissed, but to be encouraged and adopted by the next generation of immigrants. Cuccinelli said in a statement Monday evening, "We plan to fully implement this rule in 49 states and are confident we will win the case on the merits." Expanding the definition of public charge. The term dates back to 1882 when the U.S. was trying to limit immigration from developing non-white countries. The year it was first codified, the U.S. also enacted the Discriminatory Chinese Exclusion Act, which barred the entry of most Chinese immigrants on the premise that they jeopardize the good order of certain localities. In the late 1990s, the Clinton administration issued guidance saying only cash benefits could be considered when determining whether an immigrant might be a public charge. The Trump administration policy substantially expanded this term by broadening the type and amount of benefit that count against immigrants seeking to stay in or move to the U.S. Under the new regulation, caseworkers would consider enrollment in the widely used Supplemental Nutrition Assistance Program, SNAP, certain federally funded Medicaid benefits, and a variety of forms of government subsidies, housing, including Section 8 vouchers. Officials would deem an immigrant a public charge and deny the applicant if they determine he or she is more likely than not to use one of the considered benefits for 12 months or longer over the span of 3 years. On certain occasions, those deemed a public charge could post a bond for an amount no less than $8,100. To determine whether prospective immigrants are likely to become a public charge, caseworkers would also take into account their wealth, age, educational skills, English language proficiency, and health. Since those expected to be affected by the rule are not eligible for most public benefits because they aren't U.S. citizens or permanent residents, critics of the regulation say it is designed to severely restrict immigration based on those factors. This regulation is not about public benefit, except insofar as it's scaring people to stay away from public benefits, even when they don't have to, said Ron, the former Obama official. What the rule really does is it imposes a 25-factor test that's never been done before, that Congress has never authorized, that is going to make it less likely for someone to get a green card based on their age, their income, their health, the number of children they have, whether they have a mortgage or student loan, and a whole bunch of other things that have none to do with public benefit, he added. Immigration advocates are concerned about the effect the rule could have on people who are technically not subject to it. Researchers have documented a chilling effect stemming from the proposed changes that have prompted some fearful immigrant families, including families that include U.S. citizens, to drop out of benefit programs. The stringent requirements proposed by the public charge rule are not the only move the administration has taken to impose, limit, or legal immigration. In October, the White House issued a proclamation allowing the government to reject visa applications from would-be immigrants it determined won't be able to cover their medical costs. The plan, which is still being held up in court, could deny entry to approximately 375,000 prospective immigrants each year, according to an estimate by the Nonpartisan Migration Policy Institute. A proposed rule by USCIS published in November would hike petition fees for immigrants seeking U.S. citizenship, for young undocumented immigrants known as dreamers trying to renew protection from deportation, and for victims